Hello everyone. Welcome back to our channel, Immigration YTTV. We hope you're doing great. In this video, we're going to talk about USCIS update. New family visa policy raises risk of denial. USCIS has introduced a major policy change effective August 1st, 2025, impacting family-based green card applications. Under the revised rules, immigration officers now have expanded authority to deny petitions without prior notice, heightening the risk of deportation for some applicants. If you are interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. Starting August 1st, 2025, the U.S. Citizenship and Immigration Services has implemented strict new guidance that reshapes the landscape for immigrants applying for green cards through family sponsorship. These changes dramatically increase the possibility of immediate denial and could expose applicants to deportation, especially those already in the U.S. without lawful status. This video reflects a broader push by USCIS to enforce immigration laws more stringently and eliminate flawed applications from the outset. Stricter enforcement for family petitions begins in August. This new policy affects all categories of family-based immigrant visa petitions, those filed by U.S. citizens or lawful permanent residents for their spouse, child, parent, or sibling. While USCIS claims the updates align with its mission to maintain the integrity of the immigration process, the changes are being interpreted as a signal that mistakes, once considered correctable, may now lead directly to denial or deportation. Denials without warning, the end of second chances. Historically, if an application was missing documents or had minor issues, USCIS would typically issue a request for evidence or a notice of intent to deny. These notices gave applicants the opportunity to address and correct any deficiencies. That safety net is now disappearing. Under the new guidance, USCIS officers are authorized to immediately deny a family-based petition without issuing an RFE or an OID. This means if your application lacks a required form or contains unclear information, it can be rejected outright. Applicants must now submit fully complete and accurate petitions from the beginning, with no expectation of being alerted to errors beforehand. Removal proceedings loom for denied petitions. Even more alarming, the new policy enables USCIS to issue a notice to appear to certain applicants whose petitions are denied. An NTA is the formal document that initiates deportation proceedings. This risk primarily targets applicants who are currently in the U.S. without lawful status and who attempt to adjust status through family ties. If such a petition is denied, the applicant may now be referred directly to immigration court for removal. The same danger applies to individuals seeking waivers, such as Form I-601, or those intending to process their green card applications at U.S. consulates abroad. For thousands of undocumented immigrants hoping to regularize their status through family sponsorship, these changes could transform a hopeful process into a pathway to deportation. USCIS justifies changes as safeguards against fraud. In a statement explaining the new guidance, USCIS emphasized the need to prevent fraudulent, frivolous, or non-meritorious applications. The agency noted that family-based immigration accounts for around 40% of all green card approvals annually. USCIS aims to ensure these applications are based on genuine family relationships and not exploited for immigration benefits. While this rationale may appear sound on the surface, critics argue that the burden is now unfairly shifted onto law-abiding applicants who may make honest errors in their paperwork. Implications for families seeking immigration relief. For immigrants and their families, the practical consequences of this policy are severe. A single missing form or incorrect document could spell the end of their application and the beginning of removal proceedings. If you're applying for a green card through a family member, your petition needs to be complete, accurate, and well-documented from the start. There might not be a second chance. Applicants are strongly encouraged to thoroughly review the list of required forms and evidence. Ensure all personal documents, like marriage certificates and birth records, are submitted properly. Understand the risks, especially if currently in the U.S. without legal status. Conclusion: precision is now essential in family-based petitions. The August 2025 USCIS policy update represents a turning point in how family-based green card petitions are processed. The era of leniency and correction notices may be over. As USCIS heightens its scrutiny and grants officers more authority to deny without warning, immigrants must approach the green card process with precision, thoroughness, and possibly legal counsel. In a system now less forgiving, every detail matters and every error could come at a life-altering cost. With no second chances guaranteed, applicants must ensure their submissions are complete, accurate, and well-documented. Even minor mistakes can now lead to denial and removal, making expert preparation more critical than ever. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.